All right, Karen, let's get started. Thank you
Okay.
again. Thank you again for being part of this today's training. We're just gonna get started just because people are gonna eventually start logging in.
Yeah.
So let's
Yeah,
just let's just do this. Thank you.
we can send on the we'll send on the presentation too. Perfect.
Perfect. Thank you. And then it is being recorded, so this we're always try to get this into our library of videos as well. So this we always go back and relearn whatever topics are being taught. So thank you for that.
Okay, let
I
me
love
just
that.
make sure I have, here we go.
That's
Oh
so
my
great
God.
that you do that for your agents, John, because it's always good to be able to reference back, to things. So
Yes.
that's so amazing. I love that you do that for them.
Perfect.
Thank you. Thank you.
All
Well,
right,
thank you,
so we're
ladies,
going to,
again. Let's get started.
yeah, awesome. So we're going to talk about becoming a successful listing agent. I really like this subject. I think it's important, especially with everything that's going on in the real estate industry with the lawsuits against National Association of Realtors and how, the push is where the sellers may not be paying for the buyer's agent's commissions in the future. So really time to start thinking about.
Karen,
Yeah.
I'm sorry to interrupt you. I believe we were supposed to be going over overview of probate.
Oh, okay. Not a problem. We can do that. Hold on a
That's
moment.
correct, right, Jennifer?
Yes, I'm here. I'm sorry.
The class is
I can hear
overviewing
you.
probate. The class is overviewing probate, not listing agent, correct?
Correct.
Okay,
Oh,
yes,
Yes,
Karen, if we
correct.
could switch to that topic.
yeah, no worries.
Awesome.
I don't know, you guys, I'm all over the board. I'm sorry.
It's okay.
It's,
It happens to all of us.
God, seriously, is this the right one now? How's this one? This one looks like it. Okay, let me get rid of this. Okay, now we can talk about probate. Let's talk about probate. All right. Oh, no, 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 don't do that. All right. Can you see my screen? Everyone good?
Yes.
Okay, perfect.
Yes. Thank you.
Okay, so probate and real estate, and I can tell you, like, even Wendy can chime in. For probate, when we have a situation where we have like the sellers passed away, we take these probate situations very seriously because of the potential for claims. So we're going to go through the process as it pertains to what we need on the real estate side and what we need on the title side, the questions you might want to ask or need to know. But it's a good class. It's good to understand the process at least. So what is probate? It's the legal process wherein the estate of a decedent is administered. So the decedent is obviously the person that's passed away. They have real property, they have personal property, that's their estate, and it has to be dealt with. So it has to be administered. It has to be dispersed and distributed to whoever the decedent wants or whoever the court decides. But why do we do probate? Because the question comes up is, well, I have a will and my will lists out, I'm going to give my property to so-and-so, I'm going to give my property, this other property to this person. Under the eyes of the law, your heirs and beneficiaries are not legally recognized unless probate is filed. So even though I may be a single mom, I only have one child, and everyone in the world knows I have one child, and I'm leaving all my property to that child, the basically under the eyes of the law, that child's not recognized as my heir until probate is open in the court. And then the court says, yes, this is my heir. As silly as it sounds, that's the process. So that's why we open probate. We want to make sure that we have the correct people receiving the correct property, and we have the correct people that are the heirs or the beneficiaries. We have 3 types of probate here in Florida. We have a formal probate proceeding, a summary administration, and an ancillary administration. So the first one is the formal probate proceeding. And you could have passed away testate or intestate. So testate means you had a will. Intestate means you didn't have a will. So in either situation, remember why we do probate is because we have to recognize the heirs. So probate is opened whether you have a will or not. Now you can be a resident of Florida or not. So a general rule, and the rule is not general, it is the rule. If I live here, or if I live in Michigan and I have property here in Florida, I have property in Texas, I have property in other states, probate has to be opened in every state where I own property. So if Michigan was my primary residence, I can't, the Michigan court can't do anything with my Florida property. They have no jurisdiction. So if probate proceeding would have to be opened here in Florida. So it can be a formal probate proceeding. Typically it's not. It's typically number 3, which we'll talk about. So you can be a resident or not for a formal probate. In a formal probate, the personal representative is appointed. Now, if you have a will, the will usually name who that PR is. If you've died intestate, it's typically a family member, whoever's filing the petition for administration. They'll request to be the PR, or sometimes the court appoints the personal representative. It's just all depends on the situation. Now, a formal probate proceeding, the first question I always get asked is like, how long does it take? It depends. It depends on, the size of the estate. It depends on the probate court, how backlogged they are. There's a bunch of different factors that can come into play. So it's not just a, 30 days, you're good to go. Now, the general rule there is if the personal representative files a motion for the creditors, so it puts the notice to creditors that there's been a estate opened and they have a right to file a claim against that estate, they have 30 days to do so. So if we're looking at a probate docket, the court docket, and we see, motion for creditors, then we know we at least have 30 days from then before the ball really starts get rolling. After that, it all depends. I have friends that do that are attorneys that handle probate, and one guy has right now, he's going on his 10th year, 10 years of doing a probate proceeding. Hopefully we do not have that situation in any of our real estate dealings, but know that it can happen. It's usually a will contest or something. On average, you're looking maybe 60 days as like the minimum. The average is all going to depend on the county and that court. Then we have number 2, which is a summary administration. Once again, you can be a resident or not. And this is only filed if the decedent has been dead for more than 2 years. So the idea behind that is your creditors have a 2-year statute of limitation to make any claim against your estate. After 2 years, it's not open to the creditor. So it's an ancillary or a summary administration. It's a quicker proceeding because there's no one to stake a claim in the property or in your property. Or the value of the probate estate is less than $75,000. Now, your homestead property is going to be exempt from the probate. And in that case, that property wouldn't be included in that probate estate. So probate estate, remember, doesn't just include real estate, it includes, pensions, stocks, bonds, checking accounts, savings accounts. So if all of that is less than $75,000 or less, or summary administration can be open. And once again, just quick proceeding. And those are fairly quick because their decedent's been dead for a while or the estate's too small. Third type is the ancillary administration. Now, this is for non-residents only. So like I said earlier, I am from Michigan or I live there. That's my primary residence. I have a property down here in Florida. Michigan court can't do anything with this property. So we can open an ancillary administration down here in Florida just to deal with the Florida property. It's only good for non-residents because otherwise we have to do a formal probate. And we'll see a lot of these, obviously, because we have a lot of people with second homes that live in other states. So all that has to be done, ancillary administration open, and it's just to dispose of the Florida property. Now, the rule is with that, as long as the formal probate was done properly by the laws in the state that it was opened and closed in, then the ancillary administration, like down here in Florida, the courts will be like, that's fine. We'll follow whatever they say. We're good to go, but we need their stamp of approval, which is this process. So we have those 3 types of probate. What do we look at on the title end to determine if probate's necessary? We're going to review how the deceased person held title to the property, and what type of property was it? Was it an investment property? Was it a homestead property? So those two things are going to help us determine on the title on, do we need to see a probate proceeding? Or can we just go ahead with who we've got on title and all we need is a death certificate? So interest in property, most will automatically vest at the time of the death of the decedent. So that means no probate's necessary. You have a husband and wife. Husband passes away. Wife automatically gets it because they're both in title. That's automatic vesting. And then that's where we just need a death certificate. But sometimes we need a probate proceeding because we don't know who gets the property. So the properties that are, or tenancies that are subject to probate are your sole tenancy. That would be Karen Michaels, a single woman. Nobody else is in title with me. So we don't know who my heirs are. Or tenants in common. That's where you have 2 or more people in title that don't have any survivorship language. So I think, do I have these all? No, I don't have them separated out. Okay, so tenants in common would be Karen and Wendy. That's how we hold title. So we each have a 50% interest. With my 50% interest, I can do whatever I want with it. I can deed it out. I can mortgage it. I can have contracts issued on my 50%. Wendy can do the same with her 50%. But our intent was, when we took title this way, was that if I passed away, I don't want Wendy to get my 50% interest. I want my 50% interest to go to my heirs. So let's say I have 3 kids. Wendy would retain her 50% interest as my tenant in common. My 50% interest would be probated, and then it would go to my 3 heirs. And now my 3 heirs would own my 50% interest. Wendy would own her 50% interest. So this is, especially with tenants in common, when we're going through even our title exam and we find all these people kind of all over the place, you may think that you own, your co-tenant died, you own it outright. And they're like, no, no, no. You only had a tenancy in common. When we look at the others not subject to probate, you'll see the difference. So these are not subject to probate. You've got tenancy by the entirety. This is where you have a husband and wife in title together, or a married couple in title together. So I'll pick on my boyfriend. So Karen and Mark, our husband and wife, we bought the property together. We're entitled together. That's a tenancy by the entirety. If one of us passes away, the other one automatically gets the property because we took it as husband and wife. Now, that is very different than if it was just Karen Michaels, a married woman. That's a sole tenancy. And we'll talk about homestead and all of that in a minute. But my husband, that is not a tenancy by the entirety. So as a married woman, as a sole tenancy, what does that mean? That means my property is subject to probate. And it does get a little confusing, but we'll go through it. So husband and wife in title together, the surviving spouse gets the property. Joint tenancy with rights to survivorship. That is the flip side to tenants in common. That's where you have 2 or more people in title. So Karen and Wendy are back in title, but we decided to add the language as joint tenants with rights to survivorship to the face of the deed. So Karen and Wendy is joint tenants with rights to survivorship. And the intent is, if one of us passes away, the other one automatically gets it. It's an estate planning tool, honestly. Do I want my co-tenant to get my interest, or do I want my interest to go to my heirs? Now, very important for you as realtors, you do not give advice on this. This is the unauthorized practice of law. If you're like, oh, this is what happens and this is what happens. Just keep that in mind. But it's a good thing to know what these different tenancies are, because you could say, oh no, he held title with so-and-so and now he's trying to sell it. We're like, well, wait a minute. It was a tenants in common situation. And now we need to have the co-tenant's interest probated. So these are the things that, obviously we run into. The third type is these ladybird deeds and other life estates. So on these deeds, it would say Karen Michaels with a life estate, and then I'd list all my powers, like power to sell and convey, power to mortgage, power to execute contracts. I retain all my powers and rights to the property. But upon my death, my property goes to Wendy. So I name who my heir is on the face, or not even my heir, the beneficiary of who's going to receive my property upon my death. And that's, once again, a major estate planning too. Please do not prepare these by yourselves. You can pull them up off the internet and create them, but if you do that and you don't reserve the right powers, you have problems if you're alive and you're trying to do things. Or even if it's the wrong powers and the deed is done incorrectly, that property might end up in probate. But the idea is I'm retaining my life estate to do whatever I want with it, but I'm naming who gets it. So probate is avoided. So these three types, the husband and wife, the joint tenants with rights of survivorship, or ladybird deed or enhanced life estate deed, are ways to avoid probate. So when we're doing a title search and we see the last deed of record, per our search, we see this husband and wife and we know the husband's passed, all we need is that death certificate. Now, one other note on the tenancy by the entirety, we do have a document signed called the affidavit of continuous marriage. If we know that, like, let's say the husband passed away and that they were both entitled together, we'll have the wife sign this that says they were never divorced, because a divorce breaks that tenancy by the entirety and turns it into a tenants in common. So that means even though the deed reads husband and wife, but we know they're divorced, they're no longer married. So it reverts them to a tenants in common. I know it's really confusing, but this is all the stuff we have to go through. So when we have that, it reverts to a tenants in common. Guess what? The husband doesn't automatically get the wife's interest. The wife's interest now has to be probated. So I know that, like if you pulled up the last deed, you're like, well, it says husband and wife, but I know he's passed or whatever. Just, we have to find out, were they ever divorced? Because if they were divorced and they just never changed the deed, now we've got another issue. Now we need probate. We're not trying to be difficult. It's just the way the rules are. The other thing we're going to look at is the property in a trust. So you have a couple types of trusts. If we have an inter vivos trust, that typically avoids probate, and you'll see a revocable trust or an irrevocable trust, and we'll get into those a little more. But then if we have a testamentary trust, that is created in a will. So an inter vivos trust, the idea behind it is, and why it avoids probate for the most part, is because you've done sort of a pre-death transfer of property into a trust for your beneficiary. So you've already transferred your assets while you're alive. That's an inter vivos trust. Testamentary trust, you're saying this trust doesn't take effect. It's not created until I die. And you have a will that says that. So when we see there's a testamentary trust, there's a will, probate has to happen. You'll see like testamentary trusts and wills for, people that have, maybe they've got kids that they don't want to go through their inheritance. So they'll, set up a trust in their will so they don't blow through the inheritance. Revocable trust. So let's look at these because these are the most common type. And this is where the assets remain in the grantor's estate. And all that means is the grantor, the creator of the trust, can do whatever they want with their property. They can move it out of the trust. They can move it back in. They can amend the whole trust. They can revoke the whole thing. They can change out the beneficiaries. They have complete control of the trust. And but that's still there because they've already sort of pre-assigned and predisposed of their property. It does avoid probate. Trusts, on the other side note as well, please go talk to an estate planning attorney or a trust attorney or whatever, if you want to create one, because there are a lot of differences between them. And like with a revocable trust, it's easy to get a mortgage. Most lenders don't care if the property's in a revocable trust because you maintain control of your assets. Irrevocable is a little different because you can't do anything with it. As soon as you create it, it's set in stone. I transfer my assets in there. I can't amend it. I can't terminate. I can't do anything with it. Oops. I left out that. So, and if I wanted to make a change, I have to get unanimous approval from my beneficiaries. So my beneficiaries are looking at this trust like, no, we don't want you to move out the property. We want to keep that in the trust. And if they don't agree to it, you have to go to court. Irrevocable trusts also, you can't get a like mainstream mortgage. You have to go to like a private lender. So you're going to pay a lot more. There are some benefits for irrevocable trust. Like if you are a business owner and you want to protect yourself from personal liability on things or lawsuits that happen with your business for personal liability, an irrevocable trust might be a way to go. You see, my doctors have these, or attorneys even. The other reason, like I remember doing a class with an estate planning attorney who said she never does irrevocable trust unless the person is very, very wealthy and is trying to avoid the estate gift tax or estate tax when they die, and I think it's like 14 million right now. And that's really the only time they do it, because you put that stuff in, you can't get it out. So you've got revocable trust where you can still play around with stuff, irrevocable trust where it's set in stone. And they are ways to avoid probate. So we look at this, how is title held? And then secondly, we have what type of property is. Now, investment property, I don't even have it on here because you can do whatever you want with your investment property. You can will it to whoever you want. You can leave it to whoever you want. It doesn't matter. If you're single, great, doesn't matter. Married, doesn't matter. But we have a homestead rule, and this is for your homestead property. So the homestead constitutional provision here in Florida is pretty strict and also very protective. It protects your property against bankruptcy if you file the right exemptions. Obviously, we had our homestead tax exemption. It requires joinder of spouse. So that means if I'm entitled by myself as a married woman, it's my homestead property, my husband has to sign off on like the mortgage deed, anything that I'm doing, because he has a homestead interest. He's not entitled, but he's constitutionally protected. So that even extends now to probate. So under the Florida Constitution, it reads, the homestead shall not be subject to devise if the owner is survived by spouse or minor child, except the homestead may be devised to the owner's spouse if there be no minor child. If an owner of interest in homestead is survived by a minor child, the homestead cannot be devised. What does this mean? This means the Constitution is saying, if you are married and you do not leave your property to your surviving spouse, you violate the Constitution. Your surviving spouse is entitled to not full ownership, but they're entitled to that property, however it looks. So if you have a will and you leave it to your surviving spouse, fantastic. You don't violate the Constitution. You're good to go. But if you put your property in your will, your homestead property, to, your cousin, and you're married, now you have a violation of the homestead rule. Now, the whole thing about the minor child is minor children can't hold title, technically. So the idea is if you have a minor child and you're leaving this property to a minor child, we have a problem. It violates the homestead provision as well. Once again, important to always talk to an attorney, to have wills prepared or trusts. So what happens to that property if you violate the Constitution? So the Florida statutes come out with the descent of homestead. So it says if it's not devised properly, so that means you've left your homestead to someone other than your surviving spouse, then it's going to descend in the same manner as other intestate property. So if you don't have a will, then we have a chart, which I'll go through, that shows you who gets the property once you die, because we have to figure out who the heirs are. So what your surviving spouse is going to get is a life estate. They get to remain on the property. They can't get kicked out just because you left it to somebody else. Doesn't matter. Remember that actually the property is taken out of the will and is standalone now. So we're saying surviving spouse is going to get it regardless. They get a life estate though. They still have to pay any mortgage, any liens, any taxes, etc. That's all part of owning a property, but they just have a life estate. Like, remember that ladybird deed, I retain a life estate. So they have the powers to do things. If they want to mortgage it or something, then guess what? The remainder, the lineal descendants that follow after that. So if let's say I'm have a surviving spouse, I have adult children, adult child's going to have to sign off on things. So it goes to my surviving spouse as a life estate. And then if he decides, I want to sell it, then technically it goes down the chain, and then we'd have to get all these heirs to sign off. So let's take a look. I think I have it on there. No, we don't. I'll get to it in a minute. Oh my goodness, I went way too fast. So the idea is, and this is all you have to know, because this comes up too. Well, I didn't, it wasn't left to, it was left to me. I'm the oldest son. Okay, it was homestead though. So the wife gets it in a life estate. Doesn't matter what the will says. So keep that in mind. And we do get in fights all the time with people. What about the minor child? If you have a minor child, any devise of the homestead will fail. Homestead that goes through the intestate statute. Well, hold on, let me see if I have that chart. I don't know if I have that chart in here. Well, we'll figure it out. But it goes descendant or decedent, spouse, and adult children. If there's none of those people, it goes to grandchildren, so on and so forth, till we basically find a living relative. So we've got protected homestead and non-protected homestead. So homestead that passes to the protected class is exempt from claims of creditors, which is not an asset of the estate and is not subject to conveyance by the personal representative. So we have a homestead situation where it's technically it's protected. It's not part of the probate estate necessarily. So in that situation, we have the personal representative can't sign a deed. We're not going to go to the court. We're going to have the heirs sign off on that. Non-protected is that's passes subject to the claims of creditors, is an asset of the probate estate, and is subject to conveyance by the personal representative, and affected as lost its protected status. And that could be a situation with me as a single person for my homestead property. There's just certain things that, the court's going to determine if it's protected or not. But know that for the most part, it's protected homestead. We have the heirs sign the deed. And I think I have that coming up. So how do we know if it's homestead? We have a homestead tax exemption. We'll look at that. If there's a question, we might look at the last residence on the death certificate or on the petition for administration, which opens a probate. Or we might have to go back to the court and ask for an order determining homestead. And that's where the court says, this is the homestead property. And why would we do that? Well, there are situations where, there's an argument, well, the person's died. My spouse lived at another property. They didn't live at my homestead, or there's, the kid is arguing that, no, that really wasn't the homestead, and all kinds of things. We don't get involved in that. Remember, like I said earlier, we're always worried about claims when we're dealing with probate in particular. So we go back to the court and get an order determining homestead. It does several things. It confirms the property is exempt from the claims of creditors, so it's protected, and it's not an asset of the state and is not subject to conveyance by the personal representative. So we have an order determining homestead. That's a protected homestead. The heirs would be signing off on everything. Now, waiver of homestead. This is a surviving spouse may waive their homestead rights. Has to be before or after marriage, not after death. And it's a written agreement that actually we require it now on title that it be on the face of the deed. So where they're signing off on like the warranty deed that they don't want any homestead interest. But we do see like prenups, postnups, et cetera. So we want to make sure if someone's interested in waiving their homestead, that they're talking to their own separate legal counsel, because they're giving up, they can get kicked out of their house essentially. What about trusts? So I said trusts are a way to avoid probate. And yeah, it is, unless you have a homestead property in a revocable trust and you are trying to leave it to someone other than your surviving spouse. In that situation, the Constitution and the Florida statutes come into play. Irrevocable trusts are a little different because you don't maintain control of your assets. So general rule is if it's in an irrevocable trust, you can kind of do whatever you want with it, but there are, of course, caveats to it. And that's why you should always be talking to an attorney regarding setting anything up. But the revocable trust, if your idea is like, I'm not going to leave this to my surviving spouse, it's in a trust, we don't have to go to probate, it violates the Constitution if you do that. So the spouse will, once again, that property is taken out of the trust, like it's taken out of the will if you don't devise it to the proper party. And now that spouse gets a life estate, and it goes through the same process as we saw with the lineal descendants, etc. If you, in your trust, leave it to your surviving spouse, fantastic. You followed the Constitution, we're good to go. No probates needed. But that's where we see these situations come up, is someone tries to be tricky and leave it to someone other than their surviving spouse in a revocable trust. And then because it's out of the trust, probate has to be opened so we can determine the heirs. Remember, second slide, probate's open because the law does not recognize heirs until probate is open. So even though we know there's a surviving spouse and any lineal descendants, it's taken out of the trust. The trust is to avoid probate, but now we have this standalone property and heirs, we have to go through probate. So it can get really, really messy. Oh, here we go. Here are the heirs. So you have a decedent, portion to the spouse, and this is an intestate. So this is what happens if you die without a will. This is how the court determines who gets your assets. Or if you violate the Constitution in your will with your homestead property. So portion to spouse, portion to children, then grandchildren, great-grandchildren, et cetera, et cetera. So it goes all the way down, trying to find somebody who is alive. Who signs what? Who signs the deed, the conveyance document? If it's homestead and it's properly devised to the heirs, then the heirs are going to execute the deed. The personal representative is not. Now, I know there are some situations where we actually do have the personal representative and the heirs sign a deed. Every case, I'm just going to put it this way, it can be, there's general rules and then there's exceptions to a lot of rules just based on what people did in their estate planning. If it's not homestead and there's the power to sell and convey, the personal representative can sell and convey the property. If the will doesn't give the personal representative the power to sell and convey, then we need to go to court authorizing the sale. So the idea behind sell and convey, and both those words have to be in anything you're doing, power of attorney, will, trust, ladybird deed. To sell means I can sell the property. I can list it. I can sign a contract. I can sell it. But it doesn't mean I can sign the deed. We need the words to convey because that's the conveyance document. Somebody needs to sign the deed. So we have had situations where wills are done poorly and it just says the power to sell. And now we have to go back to court and say who can sign the deed, and then the court has to authorize the sale. Important powers of attorney, they terminate upon death. We'll get that. Sometimes you'll have someone, and this is, by the way, a huge fraud thing that's happening right now. With the vacant land fraud. We actually had this guy, I didn't want to say gentleman because he's not, guy walks into one of our agent's office with a power of attorney and they start questioning it, and the agent finally was like, well, I'm going to send it to my underwriter. And we did some research and found out that the power of attorney that this guy was presenting was executed and notarized 2 months after the principal, the person that owned the property, died. And this guy was arguing, oh, no, it's valid. We're like, no, these terminate upon death. So if you ever get a power of attorney, you very first question you want to ask is, where's the person that signed this? If you ever are uncertain or not sure what to ask, you call Wendy, because we take these very seriously. At no time, because the power of attorney, can you have any language that says it survives death? So if there's a death, we have to have probate, period. What happens to your stuff? What happens to all the liens and things that are on your property? So if there's a money judgment, that judgment holder becomes a general creditor and has to file a claim with the probate estate within that, 30-day period to get any monies back. Federal income tax liens, if you didn't pay your taxes, the IRS can file an income tax lien against you, and that doesn't go away when you die. IRS, hate to say it, they don't care if you die, they still want to collect their taxes. So it remains a lien until it's released. And they are good for 10 years, and then IRS can extend them for an additional 10. A lot of times though, if we have a state situation where maybe there's not a lot of money, the IRS will sometimes waive the federal tax lien and discharge it. But that's hit or miss as well. What about tax and code enforcement liens? They survive probate and must be paid. They run with the land. The property tax assessor, once again, doesn't care that you've passed. They want to collect their taxes. Same with any code enforcement lien or unpaid special assessment, unpaid utility liens, anything like that that's attached to the property remains with the property. So at closing, we have to pay all that stuff off. Condo HOA liens, exact same thing. They survive probate and must be paid. If we don't pay our condo association liens, they potentially could foreclose. What about mortgages? Mortgages remain a lien on the property. They still have to be paid. Even if the spouse gets it as a life estate, even the spouse gets it in the will, they still have to pay the mortgage. Mortgage companies are going to foreclose if you don't. Now, there is in the mortgage documents a due upon death clause. So it's an acceleration of that mortgage due date when you pass away. Now, if you talk to a mortgage company, as long as that mortgage is being paid, they don't care where the check comes from. They're not going to look at that, right? As long as they're getting paid, they're happy. It's when they go to foreclosures when they're not happy. So we do have, a lot where maybe the spouse can't qualify or something, but they continue to pay that mortgage until they want to sell it. That's fine. But when we have a person pass away and we're going through probate, that mortgage company, and we're doing a closing, we're paying off that mortgage. So we still have to pay off everything. It is what it is. We have to clear title. We have to remove liens. And, it all comes out of the state typically. So what do we need? We need a death certificate. We're going to need a death certificate in any probate situation, a trust situation, what have you. And speaking of the trust, I should have thrown this in here. If the trustee, let's say I created the trust, but I also name myself as a trustee and I pass, I will have a successor trustee named in that trust. And that successor trustee will need that information as well. But what we want to see is a death certificate. It has to be the original. It cannot have the cause of death on it. That's non-public information that we can't record because we're going to record the death certificate. And most hospitals and funeral homes have that redacted anyway. But know that we need the original. We can't have a copy. It has to be an original document. We also may need to see the will. We typically don't want to. In fact, if someone walks into your office with the will and starts, going through it and says, look, page 7, I'm the heir, I get this property, the next question is, well, have you opened probate? Because we can't do anything. We're not going to be able to get to closing until probate's opened and closed. We want that Florida order admitting the will to probate, any letters of administration. The letters of administration have a lot of good information on it. If you don't have, at least have the death certificate. If you don't have these other things, obviously the full name of the decedent as well as the county the probate's open, we can typically find that. Even if you have a case number, because we need to go work with the probate attorneys. We have to look at the docket. We have to see where we are. We have to see, was homestead violated, all of that. Other things we may need to see is that order determining homestead, that order authorizing sale if the power of a personal representative didn't have the power to convey or sell, and then any order for summary administration if any is entered. We will tell you specifically what we need, but if you're dealing with a probate situation, death certificate and any probate info you have is the key. If they're like, well, you know, it's been 3 years, my advice to you is to send them to a probate attorney that can walk them through this, because they're still going to have to close out the probate thing. There's no like statute of limitation. They've been dead 40 years and now I get the property. Well, in that case, it might be adverse possession, but that's a whole nother thing. But we want to make sure we're crossing T's, dotting I's, because we do have situations where, you know, people have done things or whatever, and then we do a closing, and maybe probate wasn't closed out or the heirs weren't recognized, and now we have a major claim. So we don't do those things. We really follow the letter of the law with the probate court. And that's all I have for you. I see there's a question. If they sign a prenup, so Wendy asked, what happens if they signed a prenup? So we will, if they have a prenup and it's waived their homestead rights, obviously it's something we definitely want to review. It'd probably go through underwriting just to make sure, you know, talking to the person. A lot of times, you know, we may accept it. It just depends on the terms of what it says in there. We really don't like being like legal experts on this stuff. But we do, I mean, we have had situations where it was in a prenup where they waived their spousal rights to the homestead property. And then it's like a case by case basis on what we do with it. But that's a good question. Any other questions? That was a lot of information I crammed in there.
It is. It's a lot of information.
I'm
Any
definitely going to
questions,
go
Jen?
back into this video and recapture everything. I need this information in my head.
Excellent.
Thank
Well,
you so much, Karen.
Yeah, I'll send you the PowerPoint as well, so you have that. And then
yes.
Oh no, my battery's running low, so they're gonna kick me out in a second. So I'll send that over to you. If you have any questions, get with Wendy. She can reach out to me as well, and we'll talk again then in April, right?
Wonderful. Yes.
All right. Take care,
Yes.
everyone.
Thank you,
so
Karen.
much. Thank you,
All
guys.
right.
Thank you, Wendy. Thank you, Karen.
All right.
If anyone ever has any questions, Jen, you know, to the entire group, if you guys ever have a question or a concern, like Karen mentioned, you know, feel free to like call me or text me. Please use me. There's never a dumb question. I would hate for, you know, you guys to lose a client or a listing or any opportunity just because you have a concern and maybe you just don't know the answer, you need clarification. There, for me, there's never a dumb question. So, you know, you can call me, send me a text or an email, or call my office. Everyone is always very happy to help. You know, that's what we're here for, to support you guys in anything that you need. Put my contact information, Mylene, on there for you to contact me. And then also Jen, I know I'm sure that she'll share my contact information if everyone anyone needs it.
That's for sure. We definitely I'll put that on the chat as well. But if you don't mind, put your phone number there or whatever, however you want. But I'll definitely go back into the chat and make sure everybody reaches out to you as well. Amazing. Thank you so much. I appreciate you. I appreciate this class, and I'm going to definitely read and listen to everything again. I promise you. I can't hear you.
I'll go ahead and forward the presentation to you guys. So you have it, and then if you you can make notes on it and call me and let me know, and then I'm here to help.
Amazing. Thank you. Appreciate you.
You're welcome. Have a good day,
Bye.
guys.
You as well. Bye.